Good afternoon, everyone. I'm Ezra Wolkelarter, Chancellor-elect of the Philadelphia Bar Association. It's my honor to welcome you all to today's Mass Torts webinar in partnership with the First Judicial District. Since its inception decades ago, the Complex Litigation Center and the Philadelphia Mass Torts program continues to remain a national model for judicial case management, balancing efficiency, predictability, and trial readiness. The court continues to attract these types of coordinated proceedings for all types of pharmaceutical, consumer product litigation, and even bellwether jurisdiction in some select mass tort cases. We appreciate the work of Judge Dan Anders and Judge Joshua Rogers, aside from the tireless work they do in their day jobs, for coordinating this important and informative webinar. The Bar Association is honored to collaborate with the court in convening and being the platform for today's program. And while I have a captive audience, allow me to make a pitch for those of you attending today who are not yet members of the Philadelphia Bar Association. My simple request is that you join the Bar Association. We are currently running a fall special where new members can join now and have membership paid for the balance of this calendar year and then the entire calendar year of 2026. As I'm sure you know, our sections and committees include groups for practitioners in state civil, business law, federal courts, and many more. These sections and committees are the lifeline and lifeblood of our Bar Association. Membership also includes exclusive benefits such as free legal research from Decisis, which gives you a national coverage, and discounts on professional and legal services, including e-discovery, digital forensics services. The Bar Association needs you, and we all need the Bar Association for our professional growth. Mass torts involves typically millions of documents produced in discovery, and the effective management of the document load, I'll call it, is the most probably significant challenge. It's my pleasure to introduce John, who is the CEO of our annual partner, Bit by Bit, who will explain the services offered by Bit, which includes a discount on e-discovery and digital forensics services to our bar members. And so his presentation also showcases the benefits of membership and also the importance of sponsors like Bit by Bit, who help the bottom line of the Philadelphia Bar Association and also help our members. John, I'll let you take over from here.
Good afternoon, and thank you, Ezra. Joining me is my business partner and head of forensics, Brett Creasy. We're excited to be here and be a partner of the Bar Association. We'll take just a few minutes to explain our team and how we help attorneys with these challenges. So in a few minutes, we'll walk through our company background, the services we offer, and what makes us different than most in the legal technology space. First, our background. My name is John Eunice. I'm also our in-house counsel. I practiced for 10 years at Jones Day, doing mostly civil defense work, but some plaintiff side work in the bankruptcy context. So litigating mass torts and other large cases like all of you handle. I then shifted to in-house counsel life at Bayer Corporation, a German company with its North American headquarters just outside of Pittsburgh. And so for 10 years, I oversaw litigation processes, retention of outside counsel, selection of e-discovery providers, and the like. I joined Bit by Bit 5 years ago as its general counsel and became CEO when our founder retired later that year. Brett, please say hello and give the team your background as well.
Yeah, great to see everyone today. So Brett Creasy, I'm the president and director of forensics. I'm sort of the IT second head of Bit by Bit. So my background is in information security. I've been with the company basically since its founding in 2007, and my focus is on the forensics aspects of the business, so more of the investigative pieces, overseeing that team, writing reports and testifying in court as necessary for a wide variety of matters.
Who are we and what do we do? We were founded in 2007, and I think unique in that the impetus of our company were actually the 05-06 amendments to the federal rules, in particular Rule 34 and the comments there too, which told attorneys that you need to pay attention to this digital stuff. This is important too. And so since our founding, we've been led by a litigator and an IT professional to partner with lawyers to help them through these challenges. So even though we have attorneys on staff and don't provide legal advice, we're not a law firm, We don't unknow what we know with our practice, and so we often function as a partner to our clients, helping with the likes of search term syntax, ESI protocols, production specifications, onerous requests, and behind the scenes, helping attorneys through these challenges, guiding them to the right technical solutions to save their clients money and to save attorneys time. 4 core services here: digital forensics, e-discovery, cybersecurity, and information governance. So Brett, next slide. Although we're based in Pittsburgh, we have colleagues throughout the country. We're actually double endorsed. Fortunate to have the Philadelphia Bar Association's endorsement. We've held the Allegheny County Bar's endorsement going back to 2008. Brett came from a large healthcare provider. I mentioned my background. We have other colleagues from other big e-discovery and consulting firms. So even though we're based in Pittsburgh, we have employees from coast to coast, about 15 in total. So Brett, door number 1, forensics for the group.
Yeah, so a lot of times when folks think about digital forensics, they think just about sort of the first aspect, which is data collection, which is, of course, an important part of it. Typically, the first step in terms of getting hands-on data for the purposes of, traditional e-discovery document review. But there's a lot more to it than that. I often like to tell folks, if you don't know anything else about digital forensics, if you've ever seen this, TV show CSI, it's somewhat like that, just we don't have touch screens and everybody doesn't look like a model. The analysis really boils down to the collection of any sort of electronic storage device. It could be a computer, a cell phone, a heart monitor, a security system, an online account, social media account, etc. And so our day-to-day jobs really entail going out, collecting that material, ensuring that it's done in a proper manner so that the dates and times and the other metadata is not changed or altered during the process, and then examining that for any sort of variety of asks that may be out there. Often we'll see questions around data theft, data hacking, harassment cases, whatever it may be, but it really boils down to who did what, when, and how. And so when we think about that process at large, it might involve, of course, extracting text messages or deleted text from a cell phone. It might be telling the story of how something unfolded on a computer, whether or not a contract was edited or things of that nature. And then ultimately writing the necessary reports for our clients to tell that story and potentially even testify about it in court if need be.
Service number 2 is e-discovery. So we offer end-to-end e-discovery support for clients that need it. The collection is the first part of that, which Brett mentioned, but we also do data processing, culling, and then hosted review in cloud-based platforms. And we have project managers across the country certified in those review tools to help the attorneys find what they need and produce resulting files to the adversary or requesting party. 2 primary platforms we utilize are Relativity, a well-known tool throughout the e-discovery industry, and a newer tool called Silo. That's a Gen AI-backed litigation tool designed for litigators for document review and other litigation functions. So we're tech agnostic. We offer both for our clients, support both, and we can offer relativity expertise as well as a Gen AI tool if there's a need to do so. Door number 3, Brett.
Yep. So cybersecurity and incident response work is, in some respects, a subset to the forensics practice. So it's often revolves around hacking cases and things of that nature. Helping our clients secure their environment after something bad has happened, typically, is when we're asked to do so. It is a bit of preventative counseling using things like the Center for Internet Security's best practices to help our clients just secure their network environment and ensure that their data can be protected. I touched on the incident response all in one go.
Yep. And then finally, information governance counseling. Here, we help counsel clients around what their corporate records are and aren't, where they should be stored and not be stored. Once records' useful life ends, help dispose of those records. So this is a consulting practice. Help clients understand record types, record locations, and how to defensively dispose of them when the time comes. That's the 4th service offering that our company can provide to our clients. What makes us different, to wrap up here? When you engage bit by bit, it's a legal, technical approach to your problems, not just a price for a vendor, but really thinking through the problems with you. You get personal service. We don't have ticketing queues or ticketing systems. You're assigned a person to know your case from end to end. Engaging with us for the whole process assures data security, our CIS membership. And then finally, for another discussion I'd love to have with you guys, we give full access to our tools. We give full access to our clients if they need it. And we don't require any minimum spend or commitment to get special pricing, which we can discuss offline here. But we have a unique model in that way as well. We don't require you to burn through volume tiers to get good and attractive pricing.
And last but not least, John, those who are Philly Bar members also receive a discount.
Yes, you get a 5% discount off of our hourly rates and our data processing fees if you engage us through the Bar Association membership. So Ezra, thank you very much. I'll pause for questions. I want to keep your agenda on task. I think we've done so, but we appreciate the opportunity and look forward to partnering with folks here on the phone.
All right, well, good afternoon, everyone, and thank you to the Bar Association, in particular to Kathy and Ezra and the Bar Association staff for their support of this free webinar. More than 500 people have registered for today's webinar, which is demonstrative of the need for forums like this to provide a better understanding of our nationally recognized mass torts program. We have many great speakers today, including Judge Rosenstengel, the Chief Judge for the Southern District of New York. And although I'd like to stay for the entire webinar, I'm actually on vacation in Joshua Tree, so I hope you'll excuse me for not staying through the entirety of this program. And most of you are aware that as the administrative judge for the trial division, I decide whether to create a new mass tort program. And in short, there's no strict rule as to when a mass tort program is appropriate, but the existence of an MDL in the federal court, such as in the paraquat and hair relaxer cases, carries significant weight, as well as the sheer number of cases that may benefit from the intensive case management of the mass torts program. Now, if mass tort designation is not appropriate, there are other options that we have in Philadelphia to manage cases that have common issues or common defendants among them. And for example, we recently started to identify groups of cases that the court coordinates under a single judicial team leader in the major jury program. Examples of these cases include construction defect cases where there's a single developer of a large residential housing development, or there are many sexual or physical abuse cases against a single defendant or group of defendants, such as the archdiocese cases or juvenile delinquent facilities. Now, to be clear, these cases are coordinated. They're not consolidated, they are coordinated. And coordination under a single judicial leader provides for uniform rulings on discovery and other motions. It provides for more efficient trial scheduling, as well as the opportunity to conduct global settlement discussions. Now, if you believe that there's a group of cases that are suitable for coordination through this program, not through the mass tort program, you should contact my chambers directly. And with that brief introduction as to my part in this program, I will turn the program over to Judge Roberts.
All right, thank you, Judge Anders. I'm gonna just throw this up there to begin. So if you don't know who I am, I'm Judge Joshua Roberts. I'm the team leader of the Complex Litigation Center, which oversees the Philadelphia Mass Torts Program. Just to get into some numbers here before we get into some more substance, the current Mass Tort Program, as you can see, we divide it into two categories. We have asbestos and we have non-asbestos, and you can see from my screen the number of cases. And I think it's important to emphasize here, we are probably at an ebb, not necessarily the number of programs, but the number of case filings. And so that's just the nature of the mass tort world. Things come and things go. But I think as Judge Anders noted, we don't need a critical mass number of cases to designate something as a mass tort. Hair relaxer currently has 25 cases, and that's probably the most or the high end of what we're going to see. You see that the Elmeron case is currently closing up, so it only has 3 cases, and the other cases are on various procedural paths. But the number of cases isn't determinative of whether something is a mass tort or not. And so I think that's an important fact to keep in mind as you're going forward. But as you're going to see from the panels as we go forward in the program, we treat asbestos and non-asbestos quite differently. And so I think to hear from the practitioner's perspective will be informative on that front. Just a little bit more data before I introduce Judge Rosenstengel. I have some verdict information. This is verdict information that is general, and I have a caveat up here on the screen. This is since 2014. And the verdict information I have here, it does not account for post-trial remittitor or molded verdicts and subsequent appellate decisions that may have impacted the ultimate number. So what we're looking at here are bands of, and these are just the raw numbers returned by a jury. And so in the non-asbestos mass tort world, we've had 29 cases go to verdict since 2014. 20 were plaintiff verdicts and 9 were defense verdicts. The plaintiff verdict numbers here include punitive damage awards. And so some of those numbers, again, it's important to note, may have been reduced or molded through a post-trial or appellate practice. On the asbestos side, we've had 25 verdicts, and that has 17 plaintiff verdicts and 8 defense verdicts. And as the asbestos panel will elaborate on a little bit more when we get to them, the asbestos world has its own adjustments that can take place. So the raw number, whatever the raw verdict might be, may not necessarily be what the plaintiff takes home, depending on settlements and the number of shares ultimately that remain in a case at the time of trial. So with that, I want to get right into our panel, and I am very, very honored and privileged to have as a co-presenter Judge Nancy Rosenstengel. Judge Rosenstengel, and I will forgive Judge Anders as he is out on vacation. Judge Rosenstengel is the Chief Judge of the Southern District of Illinois, which is in East St. Louis. And Judge Rosenstengel, before joining the bench, was a member of the Bar of Illinois and Missouri, practicing in federal and state courts. She was the clerk of court in the Southern District of Illinois, and she was nominated by President Obama in 2013, unanimously confirmed by the Senate in May of 2014. And as Judge Anders alluded to a little bit earlier, Judge Rosenstengel presides over the Paraquat MDL, which is how I got to know Judge Rosenstengel, and she and I have discussed over the many months and years of this mass tort MDL. And so I thought it would be a perfect synergy for Judge Rosenstengel and I to co-present on the state and federal issues that lawyers and judges face in terms of dealing with MDLs and mass torts. So with that, Judge Rosenstengel, I will start us off, and this is really more of a statement and a question all at the same time. I think it's important for lawyers, the practitioners out there, to know what I just said, which is these cases don't occur in silos. As the coordinating judge of a state mass tort, and as the coordinating judge of the supervising judge of the MDL, as you are, the parties should be aware that we are going to be, we should, in my view, the judges should be in discussion regularly as to what is going on with each case, and as to try to keep tabs on what's going on, so I don't get out ahead of the MDL. And by the same token, I have an understanding of what's going on in the MDL. What's your perspective on the coordination issue and how the judges should coordinate?
Well, thank you, and thank you for having me here today. So first, I think it is important to have open lines of communication and for the MDL judge to know what is going on in the state proceedings. That's something that's covered every time I have a status of what's going on in each state court jurisdiction. Early on, when I got the case, the MDL, I reached out to the state judge in California. There's a lot of cases there. And then at some point later, you and I talked. So I think it is important. And I mean, one thing from my perspective, for me personally, I would never, tell the state judge what, the timing of any trials. And I haven't done that, but I think it's good to just know what's going on with discovery, what's going on with experts in each jurisdiction, and what cases are getting teed up for trial.
In terms of challenges, and I think discovery you just hit on, to me, stands out as one of the bigger challenges in terms of coordination. what are some of the challenges with respect to discovery? And the perspective I'm coming at from is when I have a state mass tort, do you address the access that the state, the lawyers appearing in state court might have to the MDL discovery? Do those issues percolate up to you in terms of whether the shared discovery would require the state cases to be taxed against the common benefit fund, or any issue such as that, because that seems to be where the tension between perhaps the MDL leadership and the state, our equivalent of the state on the plaintiff side, sort of that tension comes into play.
I'd have that come up with respect to the common benefit fund. I mean, the issues that I've had with the discovery in state court was early on. There was a number, there had been a lot of cases handled here in Illinois State Court, and there were a number of items that the plaintiffs in the MDL wanted to have access to that were governed by a protective order that the defendants had but didn't want to turn over. And so wasn't something that I relished getting into, but ended up having to order that those documents be turned over for use in the MDL. So so far that's the only, state federal problem that I've had with respect to discovery that I can think of right now.
In terms of and the other key or issue that we see regularly here in Pennsylvania is that we have the MDL dealing with Daubert challenges, and then we have the Frye standard here. In terms, can you speak a little bit about? And I know this is always a point of contention here because the experts come here and the bar is lower, frankly, for having an expert qualified as such. Can you just speak to a little bit the perspective on that front?
Sure. Well, the Daubert issue was teed up and ready for me. I guess it was August of 23. I had several days of hearings on those and got the order out. Of course, the law is different, and mine was under the Daubert case. And so that is a higher bar. And there's not complete overlap of experts. It's my understanding that the experts in the Philadelphia cases are different. There was overlap in California, and it's my understanding the judge there, even though the standard is lower, essentially followed what I had done in the MDL. But of course, the standards are different, and I think in that situation in Paraquat, it was appropriate for me to issue my ruling, and then what the state courts decide to do with respect to similar experts, or if they have different ones, then that's up to them.
What a point you made earlier, which is what I want to return to, and I think it's the biggest one that we face when something is given mass tort status in Philadelphia. One of the first things obviously, whether there's an MDL is an important consideration. That I view the MDL typically as the center of gravity, maybe not necessarily in every case, but the MDL typically is going to have already been in place, and there's going to be a larger number of cases. So do you have any particular perspective on the speed of the state court cases, whether you have a preference for, and I know Paraquat's the one that's front and center right now, but whether you have any perspective on whether the MDL should lead, or whether the state court cases can get out in front. And specifically, I'm talking about trial settings, whether there's any value to the MDL sort of leading the way, or whether the state court, or you're generally agnostic as to whether the state court cases should just go on their own schedule.
So I personally am generally agnostic about it, and I have said that. I mean, if the state court is, those cases are in a position and ready to go, then I personally would never tell a state court judge to hold off. Seems like there might be the perception out there that that I have done that because state court cases have settled, but I don't. I mean, the status of each case, again, with what experts are chosen in the bellwether cases, and that differs. Years ago, shortly after I came on the bench, I had the Depakote mass action, which was just a lot of cases that were here in the Southern District of Illinois. There were some cases over across the river in St. Louis, and I think some of those went to trial before here. Again, it wasn't an MDL, but it was just another jurisdiction where, you know, we got to see what the juries thought of the case. And that was one too, speaking of state and federal coordination, where it was helpful. We, in my case, had a science day, and I just invited the judge from St. Louis to come over. People were in different states. I'm glad you clarified. I'm not in the Southern District of New York. Southern District of Illinois is very different. We're very small. But we're literally, I can see the Eastern District of Missouri courthouse from my office. So it was easy to just get together and we shared a science day. So that being said, I don't have strong opinions. There might be MDL judges out there who feel strongly. The MDL has to always stay ahead of the state court cases. And I guess that just goes back to one reason why it's good to just pick up the phone and for a conversation to be had.
In terms of you transitioning to the science day that you alluded to, and this is a general, perhaps not necessarily connected to the state court. What is the value in Science Day, and how do you view it as fitting in, and how should practitioners approach it?
So in Depakote, I thought it was very valuable because it's a pharmaceutical that honestly I didn't know anything about, and so it was very helpful. It wasn't, you know, everyone was there, and we just were presented with information about, you know, what it's used for, its history, different things. So that was very helpful. Now I haven't had one in Paraquat. Early on, there was some discussion, but they never moved forward with doing it. But if both sides can agree and see it as an opportunity to educate the judge on, you know, the product, the science, in a non-adversarial way, which I think it has to be, and that's something easy to coordinate, especially, I mean, that was back 10 years ago, maybe 9-10 years ago, when we weren't all as comfortable with Zoom, but certainly now it would be easy to do that. So I think there's value in it. I've only done it once, but it was valuable.
So I think one of the other things, so pivoting from Science Day to further down the line. So when you are deciding leadership council and the plaintiff steering committee and whatnot, are you giving any consideration to whether the attorneys, the plaintiffs who are appearing in front of you have cases in other jurisdictions, or whether they have all their cases parked with you? What are some of the factors that go into that? Is it your preference to have the lawyers have 1 foot in and 1 foot out, or essentially have cases in more than one jurisdiction? Is that something that factors in when you're considering those issues?
It was over 4 years ago when I selected leadership, and that was one thing I asked about, was how many cases that they had. I mean, obviously, I want people who have cases here in the MDL who have the time to devote to it. That was very important to me, that they're not so busy that they don't have time to focus on it. So I guess without saying, I mean, I didn't. I just wanted to know that they had cases in the MDL and that they had the time. So whether that means they also had cases other places, that didn't really matter. I just tried to get a wide variety of people who had the cases, who had vetted the cases that they had and had the time to focus on, getting the cases moved along.
From your personal perspective, obviously only speaking, is there any preference given to local lawyers or the value of local attorneys, or is that really not something that comes into play? Because as we will hear going forward on the panels in the next panels, I don't necessarily need all of the lawyers here to be local, but certainly some of Pennsylvania's unique practice and some of the procedures really necessitate it. I don't require every lawyer to be local, but it really is a matter of practicality to have local lawyers as what we call liaison counsel.
Yeah, I don't think that was there are some, of course, that I found to be local. I really tried to have geographical diversity, people from all over the country. And I can see in a state court case having more local people because, every state court jurisdiction is very different with its procedures and knowing the jury pool and those sorts of things. So, I did select a few local because they otherwise met the things I was looking for, but having a lot of people from Southern District of Illinois was not prime on the list.
And I guess the last topic, just we'll step back and go broader. When you were assigned the Paraquat MDL, and then just so I understand, Depakote was not an MDL; it was just a high volume or a lot of cases. Okay.
Yeah.
So when you're assigned an MDL, when any federal judge is assigned an MDL, is there preference given? Do you put in to the JPML a preference, or is that really just where the cases wind up, how the cases are first filed, or is it just no one really knows what goes into the consideration?
You mean as to being assigned the MDL? What
Yes.
goes into that, my perspective? The lawyers put in requests and the panel, holds a hearing and does it. Now, someone from the panel did reach out to me to say, are you interested in doing this? Which, I said yes, which I was thankful for because I've heard, sometimes in the past that, oh, you might be getting this MDL. And I'm like, well, that's news to me. Nobody has mentioned that. So, I wasn't familiar with the process, but someone did reach out and say, the Southern District of Illinois has been put in. Are you willing? And kind of related to that, I guess every year we fill out a survey that comes out from the JPML. Are you interested now? Are you not interested now, but you might be in the future? Or you're not interested at all? And if you are interested, what types of cases? And so, products liability is something that one of, several categories that I've said, and then you can say you don't have any interest in other types of things. So it's really up to the panel, and the lawyers do that, but fortunately they did reach out and say, are you willing?
Thank you. So last question, just from an interesting tidbit from your bio. Are you the only, or are you aware of other federal judges who were the clerk of court prior to being appointed?
So I'm the only district judge that I know of. As I've said, when people raise this before, I guess I kind of skipped a step because I know clerks of court who have become magistrate judges. And of course, a lot of magistrate judges become district judges. So there are clerks of court who have become magistrate judges, but to my knowledge so far, none went from clerk of court to district judge.
All right. Thank you. Again, it's been my honor and privilege and to have you here, and we're all thankful for your insights. And I'm happy we'll continue working together for who knows how long the litigation goes on.
Sounds good. And I will say, having been clerk of court is a good training for being chief judge, especially when the government is shut down. So
that's right. That's right. That's a unique challenge.
Yeah. Yes, yes. Okay, well, it's been a pleasure. I appreciate you all inviting me, and enjoy the rest of the seminar.
All right. Thank you so
All right,
much.
thanks.
So as a logical pivot here, our next panel is the our non-asbestos mass tort panel, and on the plaintiff side, we have Toby Milrod, who is a partner at Klein Inspector here in Philadelphia. Toby has been practicing for over 30 years with a focus on pharmaceuticals and medical devices. He has been liaison counsel in litigation before me. He has been on steering committees in MDLs, in other state courts. He was on that Elmeron litigation that I alluded to earlier. So Toby is a great authority on the plaintiff side, and on the defense side, I have Will Soxie, who was a partner at Deckert here in Philadelphia, graduate of Temple Beasley School of Law with 2 decades worth of experience. Will, again, significant experience with MDLs and state court mass tort litigation in pharmaceuticals, medical devices, consumer products, and Will has actually assisted Judge Anders with some of the treatises that Judge Anders authors here on Pennsylvania civil practice and the Olbaum on evidence book. So with that, I have Toby and Will. I will turn it over to you guys and jump in as we go forward.
Thank you, Judge Roberts. I want to thank on behalf of both Will and I, the Philadelphia Bar Association, for bringing this spotlight to really what is a crown jewel of our Pennsylvania civil practice. The Mass Tort program here in Philadelphia has been a nationwide leader and a paradigm that's been served as a model for MDLs, for state court coordinations around the country for decades. And of course, Will and I want to thank Judge Roberts for his stewardship of what is truly a complex practice with so many issues. And he helps to guide us in every single one of these and calls those balls and strikes and is fair to the parties. And we're very grateful for his leadership on that. I'm going to bring up a slide that Will and I prepared just to give everyone an overview as to what we're going to try to cover in our time today.
Emphasis on try.
Yeah, I've got to hit the share screen part, but let me just share this real quick. Okay. And slideshow. Okay. And so hopefully everyone is able to see our cover slide here and our next slide that we just want to share so everyone knows what we're going to try to do in summary. There's so many aspects that we could potentially cover as it relates to the Philadelphia Mass Tort program, but we thought it would be useful for our attendees to hear a little bit about setting up a mass tort and how the pleadings get us started in these cases. Secondly, some of the issues that have been touched upon by Judge Roberts and Judge Rosenstengel on federal-state cooperation versus coordination, issues relating to experts that are unique to Pennsylvania, particularly Fry, some overlap with 702 and the federal rules, parties' perspectives as it relates to discovery. We're going to talk about the bellwether program, test trials that often serve as a compass that directs the parties in these cases towards completion of a program, direction of where the litigations can resolve. And then finally, some of the unique aspects, given that there's volume of cases in mass tort, how do you preserve the appellate record? So I'm going to take that down. We'll come back to some other slides in a second. And
while you're doing that, before you jump into the first topic, because you always accuse me of not giving enough warnings, let me give 2. First of all, the views I'm going to express are my own, not my clients or my firm. And second, even if sometimes we might slip into language that makes it seem like all mass torts are the same, they're not. Mass torts are not monolithic. There are a few hard and fast rules that we're going to be talking about today. I think pragmatism is probably the touchstone and civility is the other. Those are the only rules. So with that, take it away.
I agree, Will. And, we start at the beginning with the formation of a mass tort. And it was interesting, Judge Anders got us started off I think we've had a little bit of a shift from where we used to be in the Philadelphia Mass Tort program. It used to be a function of, was there a critical mass? Was there 75? Was there 100 cases that warranted a mass tort? Now I think we work cooperatively with the court. I think the court is keeping an eye on the dockets in the civil program. The parties are looking at it. And then there becomes the question to mass tort or not mass tort. And it's not always the case. Sometimes there's a rub between the parties. Sometimes the plaintiffs want one. Sometimes they don't. Sometimes the defendants want one. Sometimes they don't. Sometimes the parties share the view that conclusion of a case or wherever the idiosyncratic facts or perspective of that case might not lend itself to mass tort, and both the parties come together and say, let's try to do informal coordination within the civil program. And fortunately, Philadelphia allows for both of those. I'm interested to hear Will's perspective, but on the plaintiff side, choosing a mass tort for us on the plaintiff side is what the driver on the plaintiff side. We believe that in the mass tort context, what gets to the end, what gets to the finish line is the ability to get to a trial. And fortunately, in the mass tort program, we're afforded that opportunity, but sometimes it might be for a smaller number of cases. It might be the perspective that in the major jury program here in Philadelphia, maybe that's what's going to bring the case closer to completion. Will, what are the drivers on the defense side for whether or not you want a mass tort?
Sure. So contrary to popular belief, at least I am not allergic to coordination. I think that there are times and places when it's absolutely the preferred way to handle something. We do start, or I start from the proposition that I have concerns about a sort of a build it and they will come mentality. And particularly where you are lowering barriers to entry, where you are a follow-on or a parallel to several other coordinated litigations, unmanageability becomes a real serious concern. It requires a lot of coordination. But I think for me, the touchstone is, what is the purpose? Is this the best way forward? Is this the most practical way forward? Is this just to part cases? And I think you said your goal is to get to trials because you think that that gets you to endgame. My view is a little bit different. I want to get to a just and efficient result. That might require trials. That might require looking at cross-cutting issues, understanding what the entire inventory looks like, understanding what's happening in other jurisdictions. I don't think it's a one-size-fits-all, but I think the touchstone is just an efficient result, whatever that means.
If I could just jump in, because one of the things I've heard that, and I think is worth reiterating something that Judge Andrews mentioned earlier, and the court, there's also the court's role here as well. And while we try to be proactive, nothing that Judge Andrews said or that I've said should be a deterrent to a party if a case is not sua sponte selected, possibly for mass tort coordination, to prevent the parties from filing a motion. And the reason I say that is our goal is to get these cases on the right track at the earliest possible point. And if there are a bunch of cases that we wind up noticing at a later point, 6-9 months down the road, that should have been coordinated, it's not going to be in the interest of efficiency to go forward as non-coordinated cases. Then we will coordinate them at that point, but we don't want to have to go back and retrace our steps. So it's really, the message is there is no set formula. The MDL is going to be a big factor, but it's not the only factor, and to recognize and do this as early as possible.
So once we decide whether or not it's suitable for a mass tort, how do we really get going? What's the operative pleading that drives the mass tort? And here's an interesting area where there's sometimes a point of contention between the plaintiff's perspective versus the defense perspective. Obviously, we need some kind of complaint for current and future litigants that serves as the incorporated by reference document that captures the factual averments and the legal causes of action. And we call that the omnibus or long form complaint. It's a plaintiffless, nameless, it's not factually attached to an individual. And so there's some interesting strategy that happens there. From the plaintiff's perspective, we like to see this document as an administrative document that guides the litigation for all time's sake. It's unusual that it gets amended in any large part. And so you've got to really throw in all of the facts and all of the possible legal claims. We often are concerned on the plaintiff side that the defendants now see this large device as an opportunity to take bites out of the litigation through the Pennsylvania practice of preliminary objection. So I'll turn it over to Will there for a second and his perspective on the starting of the case.
So yeah, you might be surprised to learn my perspective is slightly different. So I agree. Fundamentally, we start with the master long form complaint, and then attached to that, not literally, but following that, we see short form complaints. And this is where you get at least baseline data about and baseline information about the individual plaintiffs who have filed complaints. My view is you need to look at both the long form and the short form as a whole. Really, both of them combined are in effect the operative complaint. And I think there is a lot of value to using the long form complaint to identify and test cross-cutting issues. And it also, the long form complaint should be relevant to the case selection programs. I'm going to make up an example that probably has not happened, but let's say one party wants to have the first bellwether trial be something that has nothing to do with the long form complaint. That's obviously a sort of a cognitive dissonance. So I do think the master long form complaint is more than just an administrative set it and forget it document.
But I will also jump in here and note that a lot of the legal authority, a lot of the basis for why we do what we do in the non-asbestos mass tort program derives from the Pennsylvania Rules Civil Procedure 1041.1 and 1041.2, which are asbestos rules that allow application of those rules to other types of coordinated cases. And one of the things that the asbestos world will immediately recognize is that there's no such thing as preliminary objections demurs to asbestos complaints. You can raise your jurisdiction, your venue. You can raise your procedural, what I'll call the procedural objections, but the demur is not something that you can raise in those in answering or responding to a complaint. The concept being move the cases forward, flesh it out in discovery, and then if need be, through a motion for summary judgment, resolve some of those asbestos, unique asbestos product identification issues and so on. So that's it, and that is something that from time to time I will impose in non-asbestos mass torts, not all the time, but if I think it's appropriate, if the circumstances warrant, I may restrict the ability of the defendant to file demur preliminary objections to a long form complaint. That doesn't mean you can't file your other objections if it's appropriate, but let's move past the early litigation, the early skirmishes, and get to the facts. Let's see what facts the plaintiff had to support an individual claim.
One final quick practice pointer, particularly to those on the plaintiff side, as it relates to the short form complaint, which Will alluded to, is particularly in mature mass torts that have been going on for a while. If a plaintiff files a short form complaint, remember, they are essentially incorporating by reference all of the allegations that are in that long form complaint. If they believe that specific to that case, there are additional averments that should be part of that case, the short form complaint is the operative pleading where they add new information. Of course, once they add new information, that may be subject to preliminary objection practice, but that's an important reminder to those when you're filing short form complaint and you're saying, hey, there's something that I want to say that's not in a long form complaint.
So let me just interject, because now that we've sort of moved past the preliminary, I do want to harken back to the discussion that Judge Rosenstengel and I had and get your individual perspectives on how a case from the defense perspective and the plaintiff perspective, the benefits to having your own state court litigation or moving the case out of the MDL or not filing in an MDL. And I understand there are tactical reasons, and we saw, look, the jury verdict chart that I presented it can't be ignored. Philadelphia is a jurisdiction where parties know that the possibility of getting a big verdict is out there. So what are some of the considerations that go into that, and how you manage that, and some of the other factors?
Well, from the plaintiff side, I want to start by saying that of late, for the last couple of years, there's been a lot of personal jurisdiction jurisprudence at the United States Supreme Court that have kind of shifted the environment in Philadelphia. For the last couple of years, most of the plaintiffs that have been filed in the mass tort program in Pennsylvania have been Pennsylvania residents. Now, within the last year or so, there was a new case that came down from the United States Supreme Court, the Mallory case, that confers general jurisdiction if someone's registered to do business in Pennsylvania, possibly allowing for plaintiffs outside Pennsylvania. But one of the reasons why a plaintiff wants to bring her case in the mass tort program is, after all, she's a Pennsylvania resident and wants a trial by a jury of her peers. And so there's advantages to that. Secondly, I'll just say that it's interesting. There's also some rub that exists between the issues of state versus federal and cooperation versus coordination. And sometimes there's overlap. For many years, there have been a practice in Philadelphia that tries to do our best to maintain our sovereignty of Pennsylvania while still, of course, respecting the economies and the conveniences of not doing duplicative discovery of the MDL. So we cooperate as everywhere, and we coordinate where possible. And so one of the reasons why I think litigants like to bring their cases in Pennsylvania is to perhaps have the sovereignty and the speed that comes with Pennsylvania state court litigation. Oftentimes the MDLs are in fact larger, and it's much more about turning a tanker than turning around a motorboat. And so you get to proceed oftentimes faster in state court. And of course, you have other things in state court, including Fry and a jury of 10 out of 12 versus a unanimous verdict in federal court as well. Those are some of the issues. Will, what's your perspective there?
From our perspective, or from my perspective, I'm violating my own warning. From my perspective, yeah, I think that I'm assuming an MDL is already in existence. There is a lot of efficiency to trying to get as much of the litigation, keep it in federal court. Am I all about efficiency on this regard? No, obviously, unless and until, and here's my plug, maybe Pennsylvania should adopt the federal rule of evidence 702 or a corollary, but unless and until that happens, I'm glad I could make you laugh. Obviously, federal rule of evidence 702 is a rigorous standard, and it should be rigorously applied. Not to say that in state court all hope is lost under a Grady or Fry standard, but if we have the same experts looking at the same science or the same design issue, it seems like to avoid inefficiency and to avoid sort of disparate results or results that are at odds with each other, I would prefer to see the litigation really happening in the first instance in that MDL that's already set up. From a discovery perspective, and I think this was touched on in the earlier panel, I am a big believer that we should be trying to streamline discovery, i.e., I don't think it behooves anybody to do complete redos if there's now a parallel state court litigation, particularly if we're dealing with company witnesses, company documents. It's fairly routine that we would cross notice to try to gain some efficiencies, or offer the MDL production as sort of here's the corpus of documents you need. There's a lot of tools you can use to coordinate informally in that way to try to reduce some of the burdens. But I do think fundamentally federal court, if that's already happening and that's already down the road, that's typically, not always, but typically where I would like to be.
Will made an excellent point at the outset, that for all of these mass torts, it's not monolithic. So for example, right now we have a hair relaxer case in Philadelphia County for which there are 25 litigants. There's 11,000 in the MDL, but yet the MDL is a full year or more ahead of Philadelphia. They have completed a lot of their deposition discovery before we've even started ours. So we're doing our best to coordinate where possible to show up for depositions, but there's obviously going to need to be some Pennsylvania discovery on its own. So one case is different from the next. When they both leave the starting gate at the same time, there's a lot more issues that lend themselves to coordination than when they're different size dockets, different size timelines.
And I agree with that, obviously. One other thing, just sort of the federal state differences, and for people who are not practicing in Pennsylvania and Philly, you should be aware. We in Pennsylvania, Rule 4003.5 is the rule that governs expert discovery. There is not an automatic right to take a deposition of an expert. You need to actually get leave from court. Maybe with agreement you can do it. The flip side of that is that Rule 4003.5 says that the expert can't go outside what we call the four corners of the disclosure, a written disclosure. So it's sort of a trying to level the playing field a little bit, but you should just be aware if you're in the MDL or in some other state court where they're allowing depositions of experts, that's not necessarily going to happen in Philadelphia.
I think I would just, instead of saying four corners, which I always find to be perhaps a little limiting, fair scope is generally what we're going to apply. I think it's fair to note that four corners can be used, but I think from a judicial perspective, we're typically going to apply the fair scope of within the fair scope of the report.
And Judge Anders has already corrected me on that, and so yes, I agree. It's fair scope.
And one other practice pointer as it relates to expert discovery, touching upon what Will said in 4003.5, and this is something that Judge Rosenstengel also addressed. You're much more likely to face the potential that you will have to have coordinated discovery depositions of experts where the experts are the same in the MDL as they are in state court. If you're using the same experts as the MDL and the MDL is permitted to take expert depositions, you may have a difficult time fighting off that deposition applying in Pennsylvania. Whereas if you have completely different experts that are not using the MDL, I think you have a much better chance that the rule of 4003.5 that does not automatically permit depositions will take hold. Will, do you want to move over to with our time remaining to the bellwether thoughts that we have?
I'm going to ask the judge if we have permission to go over time, because I think the red light is maybe already on for us.
I think we have. Let's take about 5 more minutes, and then we. Okay. And then we'll turn. So let's go about 5 more minutes, then we'll turn to the asbestos folks.
Super.
So, from the standpoint of bellwether, Philadelphia has long been a leader also in bellwether or test trials that help shape the outcome of a litigation. And once again, it's not monolithic even in the way in which we go about the selection plan or the methodology. Sometimes it's what we call FIFO, first in, first out, chronological. Whoever filed first, that's going to be the first trial. Sometimes it's randomization. Sometimes the parties make picks of those cases. Sometimes that's modified by after the parties select those cases they want to go to trial, the other side, after taking some discovery, individual discovery, gets to strike off the other's selections. So you get a little bit more to neutral ground, as it were. You're not getting barbells of the very best and the very worst. All of these are methodologies that have been employed of late. I think Judge Roberts may share views that he shared in some of our case management conferences of late, that I think the court knows and has tools to know how to come to a resolution in these cases. I think Judge Roberts will correct me if I'm wrong. I think the court is interested in how the parties view what might be a successful methodology to going about bellwether. But just because that's what Will and I think is the best way to map out bellwether trials doesn't necessarily mean that's the way it's going to go down with the court.
So from the court's perspective, my biggest concern, or the biggest factor to me is that the parties buy in, and whether that's randomly selecting or the parties agreeing on some methodology, the parties have to buy in, because as we saw at the beginning, there are some eye-popping numbers on verdicts, but if there's nothing that's going to be derived from those verdicts, then what is the value of the trial? I understand the plaintiffs want trials and the defendants don't want trials. What I want are trials that are going to move the ball forward to get to a resolution. And so if we're just going to have trials for trial's sake, that sometimes that has to happen. That's not to say that there isn't a place for that. But what I really want to see is a trial, as a bellwether process, or trials where the parties can actually derive value from it and be able to frankly and candidly assess and start coming up with case values so that they can work towards a resolution. Because as we all know, whether it's 400 plus cases in Roundup or almost 1,400 cases in Paraquat, not every case can go to trial. So at some point we need to figure out some way to get to a resolution. And so for me, however we get to that process, I just need the parties to buy in. And what I am noticing, and this is my own personal perspective, and I don't want to say that any other judge might differ, it's becoming more apparent to me that I need to take a more active role in that, and whether it's randomization or some other methodology, just impose it. But I always want to give the parties the opportunity to come to the table, get together, and agree. But if you can't agree, there needs to be a backstop, because leaving it up to the parties, and then if the parties are skeptical of the results or skeptical of how we got to a bellwether selection, then what's the value of that trial?
Yeah, I just picking up on that. I agree. You know, I used to be a hard line. It should always be random. I now appreciate that maybe my views have evolved and a human touch can be helpful. A hybrid method can be helpful. But I do think if you're just doing party selected cases, the risk is, what are you really accomplishing? You know, from the plaintiff's perspective, I'm not putting words in your mouth, Toby, but you know, you might think that, well, if we get it has an interim effect, that it's going to hasten settlement if we just get a trial on the books. But does it really? And is that sort of empirically borne out? I'm not so sure. It could make settlement harder depending on the result. And of course, from my perspective, if you've picked the case and then you ring the bell, I say, well, but of course, it was your hand-picked case. And now let's do my hand-picked case. And you dismiss that case. So now we don't really know, going to the judge's point, we don't know what the inventory as a whole looks like. So I think we have to come back to the touchstone, which is, what's the purpose of the program as a whole? It's cooperation, coordination, efficiency, and getting to that just result, the efficient and just result. And I think the only way you can do that is to work collectively, the court and the parties, to come up with a way to assess a representative sample of cases. And I think that isn't just trials. I think it's also, you got to dig into that inventory. You've got to see what are the true representative factors that are going to drive ultimately, whether it's dismissal, is my hope, or resolution. I think that's the goal here.
That's the reason I think on the plaintiff side, it's often been the perspective, and I think there is empirical experience that when the bell has rung, it creates risk to the defendant and they might hasten to get to the table. Whereas there's risk for the plaintiff that when the defendant gets to choose cases that point out, like, there are a number of bad fact patterns, quote unquote, bad fact patterns that will either lead to dismissal on summary judgment or defense verdict at trial. That creates risk for the plaintiff. So sometimes the barbell, the ends of the barbell can help with resolution. That's, I think, the reasons over time why the parties have liked to pick their own cases. But like I said, there are lots and lots of ways to get to resolution.
So let me do this. Let me quickly fast forward the last point that was on the outline, which I think is an important one. So I don't want to lose it before we move to asbestos. Preservation of appellate issues. I think we can divide it into two buckets, and I'll sort of paraphrase some of the materials that you guys had prepared on the preservation on non-trial preservation. I will tell you that I will always give the parties every opportunity to preserve issues, and I try to work that into everything I do. My job here is not to create rat traps and waiver traps. If legitimately reasonable minds can differ, and if the Superior Court wants to, if you want to go to the Superior Court, that's your right. And so I do try to give the parties the opportunity to preserve every issue pre-trial, some of the unique procedural wrinkles with getting these cases to trial and doing deeming orders and whatnot. I will always give the parties the opportunity to try to preserve issues. On the trial front, I know that the practical advice that you would give is always have someone sitting and trying to note objections and so forth, so there aren't trial-related issues waived. Do you want to, one of you want to devote about 30 seconds to that before I move to the asbestos folks?
Go ahead, Will.
I mean, I think you've covered it perfectly, Judge. You know, you just have to, I know we don't like to always object in the heat of the moment for optics reasons, other reasons, but it's really important to think about that appellate record because waiver is strict in this jurisdiction. So I think, unless, do you want us to show very quickly the website and plug the website?
Why don't we hold that for like the last 2 minutes? So we'll come back to that. It's
Great.
Slides just to plug the website. But right now we will shift gears to asbestos. And I have a thank you, Will and Toby. So I have
Thank you, Judge.
asbestos panel. So asbestos is a special place in my heart because of how well the parties get together, how well they work together. That's not to say that non-asbestos mass torts aren't hardworking, good attorneys, but the asbestos program in Philadelphia dates back to the 80s, and there are still some attorneys practicing in front of me now who helped start the program, who were law clerks for judges for the program. So I'm honored to introduce Beth Ann Kagan, a partner at Shine Law in Philadelphia with 3 decades of advocacy and working on asbestos cases, specifically mesothelioma and lung cancer. Beth Ann graduated GW and Villanova Law School. She began her career clerking for Sandra Mazur-Moss, who was the coordinating judge of this program several iterations before me. And Beth Ann sits on the Board of Governors of the Pennsylvania Association for Justice and heads the Mass Tort Class Action Committee. On the defense side, I have Tracy McDevitt Hagan, who is one of the founding partners of Riley, McDevitt, and Henrik, and her areas include representation in these mass tort cases, both on the asbestos and non-asbestos side. She serves on the Philadelphia Court of Common Pleas Mass Tort Advisory Committee, which I oversee, and Tracy sits on the board of the Friends of St. Malachy School here in Philadelphia and is co-chair of the Mercy Outreach Community at Waldron Mercy Academy. So with that, I will turn it over to Beth Ann and Tracy to guide us through some of the asbestos, the finer points. I'll also note before they get into their presentation, I have presented on asbestos at conferences here in Philadelphia and in Charleston. So I want to try to make this more about the practitioner point of view from the practitioners and how they manage the asbestos program here in Philadelphia. So take it away.
Thank you, Judge. And I do want to thank the Philadelphia Bar Association for having this very relevant, or hosting this very relevant webinar. The number of registrants obviously show how important the mass torts are in Philadelphia. And Judge Roberts, thank you for having us. So while we are, Tracy just put up what we're going to be covering at rapid speed. But we're a mature litigation going on for decades. Tracy and I both have been practicing for over 30 years. But it's still evolving litigation. And one of the reasons it works well in the court system is the flexibility that the court has given us in terms of communicating with them, suggesting changes that might help things and vice versa, because we move along. And you'll hear a theme as Tracy and I speak about how the judge alluded to this, our early on cooperation with one another between the plaintiff's counsel and the defense counsel have really helped take care of so many things that never even appear before the court because we can resolve them on our own. So while we are a well-oiled machine, I will say that the call the list that's monthly that Judge Roberts reinstituted actually is really, there's a lot that goes on. I know the judge has said he can hear us, but not what we say behind the door. When he's in chambers, a lot gets done in just a few moments every morning a month. With that, let me address the case management order that has been in place since the Judge Fletman, who preceded Judge Roberts. It is a very instructive document. It's not, definitely it's been tweaked along the way. However, that's one of the reasons that counsel that's local, coordinating with local counsel, if you are not a normal everyday practitioner in Philadelphia County, is really important, because even the case management order might be out to date if, a month or 2 or 6 goes by. So the way our cases start, as Toby had talked about, we have a long form complaint dating back, I believe, to 1985. It's still in force. And we just file a short form complaint with relevant information that incorporates the long form complaint. How our cases get litigation grouped is that we, about every late spring to early summer, are given a list of all asbestos cases, regardless of disease, filed in the county basically a year and a half prior. So right now, we have a trial list for 26 that are cases filed in 2024. So what happens is all counsel, through liaison counsel, are given these lists, and we group our cases. And I'll explain how they're grouped, but a litigation list will come out by the end of the summer every year. So we know what the next year looks like ahead of time, which is very helpful. The cases are grouped by same disease, so mesothelioma, lung cancer, other cancers, asbestosis by disease, and by plaintiff's firm. Once we get the groupings, then we get a chart. And that chart is so important. It literally goes up on my desk every year with a large piece of duct tape, and it doesn't move. Because the entire program moves backwards from certain dates that are backdated, if it makes sense, from the jury selection date. So the whole program runs from a date in the future, and we just count backwards. But this chart is very important. If you don't typically practice in Philadelphia County, be happy to share that with you. It really does help to make things move along. With that, we're going to talk about discovery and depositions. Tracy, do you want to pick up on that?
Sure. Good afternoon. I wanted to just talk briefly. The good news about our small amount of time to talk about asbestos is that because it's a matured litigation, a lot of these things just work out. Like His Honor said, and Beth Ann had echoed, is this is a litigation where we play nice in the sandbox. I think the cooperative nature of it makes some of these topics are going to be a lot shorter than you might think. So my discovery topic is really, there's not a whole lot going on. You don't see discovery motions in asbestos. It's very, very rare. I cannot remember the last time I had a discovery motion against my client or filed on behalf of my client against the plaintiff, because it usually is you pick up the phone, you dial, or you shoot an email to your adversary, and these things get worked out. So Judge Roberts does not see us often. He does not want to see us often at the call the list complaining of these things. The only thing that comes up from time to time, again, with the cooperation of our adversaries and the blessing of the court and the help of the court, is, getting pathology, getting our Social Security records. Certainly that's not going to get easier with the government shutdown. But in those instances, 100% of the time in my history of doing asbestos litigation, a phone call to my adversary saying, hey, I need this stuff for trial. We've got a trial date, or we have a deadline of an expert report. And I don't remember a time where I haven't been given the courtesy from my adversary. Sometimes we need to reach out and get the blessing of the court. And again, I have no memory of that blessing not being given. So that is written discovery. We don't see a lot of written discovery propounded upon the defendants, because if I were to get it, I could call and say, I have 42 sets that were served all across the United States. Is there something new that you need? And of course, if there was something new, Judge Roberts would compel me to do it. So I'm going to give that and avoid that trip to the call the list where I'm going to have a motion to compel against me. So these things are worked out. In the words of Judge Moss, we play nice in the sandbox. So that's usually how these things get resolved.
So I was going to address now how we do our depositions. So we have typically about to die plaintiffs, and they're exigent, they have to be taken. So again, both sides of the bar work together in getting these Debene essay depositions done. We videotape them. Thanks to COVID, they are now done largely by Zoom, and it's worked out really well on both sides. I know Tracy will address the volume of depositions that can occur in any given week, which is difficult for the defense side to manage. So what we do is we just send a deposition notice 2 weeks prior to the date that we expect to begin, and we propound with that with the deposition notice the standard set of interrogatories that long ago was blessed by, I believe, Judge Moss. And that way they have a preview of the case. It might have been filed the week before. We call up counsel. You might not be served. Will you come and attend? You can put your objections on the record. But it's been, I think both plaintiffs and defense side would agree that it's really worked out. It's limited travel of all counsel. I mean, it's been a very good thing. So a bonus from COVID. I know that Tracy has a defense perspective on this, and I think it would be helpful for you to give your insight.
Sure. I mean, I agree with Beth Ann. It is working. The remote deposition process is a great cost savings to clients and my clients that are insured by carriers, and that is resources that can be otherwise used to resolve cases or to keep a company solvent. So remote depositions that avoid cost of travel is a benefit to all litigants. The one thing that Beth Ann alluded to is we are seeing an uptick in multiple depositions on a given day, and that can be a real logistics nightmare. Again, in the spirit of our cooperation, we're getting on the phone. I have to give a plug to our liaison counsel, Larry Brown and Catherine Jasons. I always feel bad for Catherine Jasons because she's like our complaint box. We call and say, hey, there's 32,000 depositions on Thursday, and magically she makes a phone call either through Larry or directly to counsel, and lo and behold, those dying deponents, maybe the coworker ID cases, we see some help on that. The one thing as a practice tip, I would just, in our office, we're getting used to sort of a new normal a little bit. We see a lot of plaintiffs being filed new complaints on different dockets. So if you are, your client gets sued in one of the newer dockets for that same plaintiff, you may not know that there was a deposition that was taken earlier under an earlier docket. Eventually, we understand these plaintiff cases will be consolidated, of course. There wouldn't be duplicative discovery. And the dep notices so far don't have all the captions. We're working with our adversaries to help ourselves on those things. But that would just be my little plug for a practice tip for those of you attending a deposition. You get a dep notice. You want to do a search of the docket, call your adversary to see if there's if there's been a deposition so far. Other than that,
can I just jump in real fast? So
sure.
I just want to pivot off something that you said, because it's really important, and I think it overarches this entire presentation. The importance of having, it's more so than the non-asbestos mass tort, the importance of having local counsel who has a relationship with liaison counsel, knows the procedures. The procedures here have evolved over the years, as Beth Ann noted, but they are still largely the core same procedures, and the on the ground lawyers here who have been doing it and can work together and have worked together is such an important part of the success of this program. And so that's not to say that lawyers, that particularly plaintiffs' lawyers from other jurisdictions can't come and file here, but if you do, you should have local counsel, or you should spend a considerable amount of time familiarizing yourself with the local rules and practices so you do understand how things go, because I think it's worth noting that I think I said at the beginning, asbestos and non-asbestos both fall under the mass tort umbrella here. They are treated procedurally extremely differently by the court. And so it's important for the parties to know where you are.
And then one last point on the depositions. Our rules allow us to have one counsel. If plaintiff's counsel is present, one defense counsel can be present, as Beth Ann said. One thing, we'll just sort of a shout out to the defense bar to try to share that burden, because we want to make sure that our clients' rights are protected, and it makes sense if there's a plaintiff lawyer present with the witness. It would also make sense to have in-person attendance by your defense counsel.
And with that, Tracy, typically there is a defense counsel that our dep notice says if someone is going to attend, contact plaintiff's counsel and let them know. We're often in someone's house and the person's dying, maybe in a bed or on the couch. It's a little awkward. But in the old days before COVID, unlike the other mass torts, we could have 20 to 40 defense lawyers, and the poor plaintiff would have these defense lawyers sitting either around their living room, on the floor, or we used to get conference rooms somewhere that would fit all of these people, which caused a lot of anxiety on a person who's dying of a disease. So I think all around it's moving much more smoothly. I also, and I highly recommend this for plaintiffs' counsel, whether you be local or national. When I'm going to take a defendant essay deposition, I try to notify all counsel about 2 weeks in advance of my notice, let them know I'm going to be scheduling it. It helps the defense get their ducks in order. I'm often asked, will I be identified? I can never promise anything, but to the best of my ability, I give them a little overview of the case, which helps. Sometimes, the complaint was just filed. This all makes everything move so much more smoothly. So I highly recommend reaching out and getting in touch with the defense counsel once you even have a thought that you're going to be scheduling depositions. With that, I think we're going to move on to motions for summary judgment. You good with that, Tracy?
Yeah, that'd be great.
Okay, so Judge?
Go ahead.
Okay, so in Charleston a couple weeks ago, there were other judges that ran asbestos dockets, and they were very interested in Philadelphia's motion for summary judgment practice, specifically in the asbestos program. And I think it really works. I'm going to explain how it makes everybody, I think, happy enough, and it benefits the program moving along. So here, motions for summary judgment are filed prior to mediation, which we will get to, specifically 80 days before jury selection. But the plaintiffs don't respond. We do review, obviously, what's been filed. Mediation then occurs, and I believe Tracy will address that in a minute. And anybody who doesn't settle, any defendant that's not settled at the end of mediation, those motions get ruled on. And plaintiffs have, it's actually a pretty short period, I think it's a week, could be a little bit longer, to allow us to respond to the motions. Time gets real tight if mediation fails, and then they're ruled upon. So it's less of a burden on the court. It's less of a burden on plaintiffs' counsel, defense counsel. They do show us their cards, their arguments in advance of mediation, which I think is actually very helpful, because if I have a weakness in my case, call it out ahead of mediation. I want to know about it, what their argument's going to be, if I'm going to have to change up how I'm thinking about the case going into mediation. I also, when we give demands, and I think Tracy will also address that, I often say, oh, I saw your motion for summary judgment. I don't see exactly what you're saying. I think it's a little different. At least it tells us there's going to be some butting of heads, but in an amicable way, at least we can get that out there before we go to mediate. So that's the overview of how we do our motions for summary judgment. I think Tracy has some points to make from the defense perspective.
Yeah, the only real briefly is the defense perspective is, obviously, we like to file our summary judgment motions because I think, to the extent that you're trying to leverage a better resolution or a potential dismissal voluntarily, on the other side of it, no complaints with the case management order on that front. And the trade-off, as Beth Ann alluded to, is the plaintiffs do not have to respond to our motions. Obviously, they're not responding to other defense counsel motion. That does, from our point of view, does challenge and compromise our ability to understand shares, what will be the opposition to our motion. In a perfect world, we do have that conversation substantively with folks at Beth Ann's firm or otherwise. But oftentimes, you're left a little in the dark as to what will be the real the folks left at trial. Because, if you have a case where there's 22 shares, and I don't know, some of them are new to litigation. I mean, obviously there are some very mature defendants, but there might be a company that I don't recognize. I don't know if it was Robert's Gaskets and they only made packing or that they weren't around during the years that the alleged exposure is. I wouldn't know that because I haven't, I don't have familiarity, or I don't know if Beth Ann has evidence to the contrary, because again, we haven't had an opportunity to see that. But it's a great trade-off because our clients get to have a meaningful and full exhaustion of mediation before they have to spend costs on things like expert reports. And we'll get to that. So it's a trade-off that I think is a good benefit to the defense.
So I will say this, we got like 2 minutes.
Yeah.
So let's see how much we can cram in 2 minutes.
Yep. Should we go to mediation, Beth Ann?
Yeah, you want to do mediation as fast as you can, and then I'll just get to the trial process.
Yeah, I think the big message for mediation is, capital letters, yellow highlighter, that is the hallmark of the asbestos program. That is why there's so few trials. There's been 2 trials in the last year. There is a take-home trial right now against U.S. Steel with David Halpern's firm. But the mediation is successful. From a defense perspective, we'd ask, get those demands to us, real demands, some meaningful engagement before the mediation is helpful, and knowing share counts. I can't tell you, those of you who don't do defense work, you don't realize as a defense counsel, we have to report to our clients potentially 5, 6, 7 different carriers, a national counsel, and try to predict and value cases based on what is known at the time. To go into mediation where you learn for the first time that there's 8 shares when you counted 32, it really makes a difference. And we can't turn around our valuation by the end of the day to get a change in our valuation, to get meaningful discussion. So my hope at the end of this this discussion is that those of you on the plaintiff bar will give us a call and try to nail down shares and work through those issues where we might have disagreement, and get real demands to us far enough in advance of the mediation, so we have time to get our homework done with our clients to get meaningful money if we're going to negotiate at mediation.
So I actually learned a lot from Tracy on that front, and I do encourage all plaintiffs' counsel to listen to what she had just said and definitely try to communicate as early as possible. So if mediation fails, the last thing in our program is the trial and the process of going to trial. And this is there's in neon lights here. There's a little bit of a change in the program. So if mediation fails, the mediator contacts Judge Roberts. Within 30 days, there'll be a pretrial conference. If it does not settle, you should have less than 3 or less defendants, and you will get a trial date now 90 days after the pretrial conference, and there'll be an order. And I'm just going to wrap it in, Tracy. Expert reports from the defense used to be due 10 days before jury selection, which was after the motion to eliminate deadline. So now the defense will be producing expert reports 30 days before the jury selection date. It allows plaintiffs to, 1, see what the defenses are leading up to the jury selection, might change our view, but also to file motions eliminate if needed. So you get an order with the lineup of how trials are going to be scheduled. I'll address that in 1 second. Motions for summary judgment will be decided. And then you get a trial slot about 90 days out. And again, plaintiffs and defense counsel communicate, are you booked on another trial? Do we have to move this? And the court also has been quite flexible with us, which we really appreciate. So every month there is a pecking order of trials that go out, cases that go out to trial. There's a lead case. If that lead case settles, the next one on the list is up to bat. If that case settles, and so forth, and there can be 5 or more trials listed. It's challenging. We have everybody in order, courtroom technology, expert witnesses, everyone's coming in, only to find out that the lead case went out. So, it's tough on both sides, but it is reality at this time. And again, because most cases settle, there's not, sometimes putting your feet to the fire, whether I like it or not, does make cases resolve prior to the jury selection. So if nothing else, that does, I think it helps the settlement of the cases that are listed for trial. Tracy, you have anything to add?
All right. Thank you, guys. I know it was a lot in a little, and I really appreciate the perspective that you provided. Toby, is it possible for you to throw up your screen with the website? And so as we conclude, I can sort of walk through. So if you put up your screen from the website slides, that would be great. So this is just the last thing. It's a pitch. So first of all, I have a great staff here. I know that I'm putting on this presentation, but I wouldn't be able to do what I do without Stan Thompson, Matt Allen, David Ritchie, Richard Wood, and Michael Bonner, who are the staff attorneys in the Mass Tort program. We have a website. It contains a ton of information. Will and Toby were kind enough to put it into slides. It's constantly evolving. We're making an effort to really update it. But I just really want to emphasize that website contains, from the asbestos and non-asbestos front, a lot of the documents, materials, and other forms that we use here. It's all there. It's not immediately intuitive. We're working to make it more intuitive, but a lot of those materials are there. And as everyone should know, if you need anything, Stan is always there, Matt's always there, and I know they get calls all the time with questions. They're always happy to answer your questions and point you in the right direction. So with that, I want to thank Toby, Will, Beth Ann, Tracy, Judge Rosenstengel, Judge Anders, Ezra, and the entire Philadelphia Bar Association for allowing us to put on this terrific program. Thanks all to the panelists and to everyone who attended, and hopefully we will do it again.